Welcome to this mini lecture, which is on children, consent, capacity and competence. So this is the second part of this webinar, and the first part was giving you the introduction to everything. So this part is mainly focusing on Gillick competence, and this is all down to this very important case law of Victoria Gillick versus West Norfolk and Wisbech Health Authority from the 1980s. So Victoria Gillick was a mother of 10, and she challenged the Department of Health, who'd created a document which stated that doctors were allowed to give contraception to girls under 16 without parental consent. So I don't know how she found the time being a mother of 10, but I believe she started a petition and got lots of signatures and then sought a declaration to say that none of her children under 16 could be prescribed or advised on contraception without parental consent. And she took it all the way to the High Court initially. And the High Court ruled that it was lawful for doctors to prescribe contraception without parental consent. The decision was appealed and it was taken to the Court of Appeal, and then it was taken to the higher court, which was called the House of Lords at the time, which is now the roughly equivalent thing to the UK Supreme Court. So it's taken to the highest court in the UK, and eventually they ruled that it was lawful, and they maintained that judgment made by the High Court that it was lawful for doctors to prescribe contraception without parental consent. And they came up with this concept of Gillick competency, which is something that reaches far wider than the topic of contraception. And they also created the guidelines called the Fraser guidelines, and that was named after Lord Fraser, who was one of the judges in the Gillick case law judgment. So let's talk about Gillick competency. So Gillick competency, although the whole case was about contraception, the actual concept and the law of Gillick competency, it's used far more widely than this. So it's about any decision when we're thinking about obtaining consent from children. And the judges in the judgment said, if they have sufficient understanding and intelligence to fully understand what is involved in a proposed treatment, including its purpose, its nature, likely effects and risks, chances of success, and the availability of other options, then they can be considered Gillick competent. And they also mentioned in the judgment, parental right yields to the child's right to make his own decisions when he reaches a sufficient understanding and intelligence to be capable of making up his own mind on the matter requiring decision. And that's a very wordy way of saying, so in the first part, having the sufficient understanding and intelligence and thinking about the alternatives and the availability of other options. I like to consider that as a bit like a capacity assessment in a child, but as I mentioned in the webinar before, we should try and stick to the term competency in children because we're thinking about a legal definition of competency. But you can kind of consider it as something that you do is assessing whether a child is able to understand and weigh up treatment decisions. And of course, they need to be able to communicate and retain information as well. So it's a bit like doing a capacity assessment that we would do in adults, but in children. And then this second part is a very wordy, very nice and eloquent way of just saying that parents have rights over their children to make decisions regarding the child's health and welfare only until the child is sufficiently intelligent and sufficiently mature enough to make their own decisions themselves. Moving on to Fraser guidelines. So people often get Gillick competency and Fraser guidelines mixed up, and I even hear some people say Fraser competence, which is definitely wrong. So we should try our best to stick to the terms Gillick competence and Fraser guidelines. So Gillick competence is something that we all need to understand if we work with children, because it's all about obtaining consent from children in any situation. The Fraser guidelines, you only need to know about it if you're a healthcare practitioner who gives out contraception or advice to children regarding contraception and sexually transmitted infections and termination advice to children. So you don't need to remember Fraser guidelines if you're a police officer or a social worker, but you do need to understand Gillick competency. So the Fraser guidelines are just for practitioners, and what they basically say, and as I mentioned, it's named after the Lord Fraser, one of the judges in the case, and it says that practitioners using the Fraser guidelines should be satisfied of the following. So if I'm thinking about giving emergency contraception or prescribing contraception to a child, I need to be satisfied that the young person cannot be persuaded to inform their parents that they are seeking this advice or treatment, so you should encourage them to speak to their parents about it. The young person understands the advice being given. The young person's physical or mental health, or both, are likely to suffer unless they receive the advice or treatment. It's in their best interest. We always do things that are in the best interest of the child. So it's in their best interest to receive the advice, treatment, or both without their parents' consent. And the young person is very likely to continue having sex with or without contraceptive treatment. So if you're satisfied about that criteria, you can give out contraception and advice regarding sexually transmitted infections and termination without the consent of their parents. Although initially the Fraser guidelines were developed in this case about contraception, they have later been extended to decisions about sexually transmitted infections and abortions and terminations as well. So I wanted to discuss an interesting case, which is of a minor in 1993, which helps us to understand this concept of Gillick competence. So I'll very briefly talk about it. So it was a 15-year-old girl with a very serious mental illness. A psychiatrist assessed her as being Gillick competent. However, it was noted that her mental state fluctuated so much day to day. And essentially, the courts disagreed with the psychiatrist who made this assessment, because their opinion was that she's not Gillick competent because her mental state is fluctuating so much that on one day she may be considered on a good day to be Gillick competent, and on another day or on a bad day, she was not Gillick competent and was sectionable under the Mental Health Act. When we're thinking about Gillick competency, it's important to think about it as a developmental concept. And Lord Donaldson said, no child in that situation can be regarded as Gillick competent. Gillick competence is a developmental concept and will not be lost or acquired on a day-to-day or week-to-week basis. In the case of mental disability, that disability must also be taken into account, particularly where it is fluctuating in effect. So Gillick competence is something that isn't defined by the age of the child. It's not defined by a set of questions either that you ask the child. A healthcare practitioner needs to speak to the child and consider decisions related to the child itself. So things like the maturity level of the child, the age of the child, the developmental stage of that child, the child's intelligence. And then we also need to think about the decision itself or the intervention itself. So how complicated is that decision? If we're thinking about two different interventions, let's say a blood test versus chemotherapy. One is a simple blood test, and explaining that to a child isn't too difficult. Many children will understand what a blood test is. That is significantly easier than explaining what chemotherapy involves and the consequences of having chemotherapy and all the side effects and alternative treatments and things. The sort of competency level needed for having a blood test is lower than the competency level needed to undergo chemotherapy. So in summary, in this part of this webinar, I've talked about Gillick competency and how it applies to children under 16, and talked about it being a concept that is case law. That is very important for everyone to understand, but it's not defined by a set of questions, and it's really down to an assessment to see if the child fits that criteria of being Gillick competent, and about being able to understand and considering the intelligence and maturity level of the child, being able to understand the alternative treatments. So in the next session, we're going to talk about Mental Capacity Act and the principles of assessing mental capacity. and that's for children over the age of 16, and of course applies to all adults as well.